Yes.
My Lord, hopefully I can have a short but useful stint as night watchman this morning. 30 minutes, as offered and gratefully accepted by me. 3 quick matters to deal with. First, hopefully you should have received, the court should have received a copy of the transcript. Just wanted to check whether you have.
Yes, I believe so.
That. Second, I referred the court yesterday to the reservations and observations on Article 1 in the 2014 commentary, and said that the UK and Ireland haven't made any relevant reservations or observations, and I undertook to provide a copy. The copy is on the desk and hopefully was sent electronically.
Yes.
So this is the 2014
yes.
version.
I should note Ireland does make an observation on Article 1 at paragraph 27.5, but not in respect of the commentary in paragraph 21.4, which is the commentary that I placed reliance on. Third point was that my Lady Justice Falk asked me whether the test in lifestyle equities had been applied in a tax case, and I said, and in particular the specific statutory context of tax appeal, I said yes it had and referred to Urenco, but I didn't actually take my lady to the relevant reference, so I can just do that briefly, my lady. It's in Urenco, which was a capital allowances case. Specific question was the disputed expenditure incurred on plant. It's a unanimous, it's the court's unanimous decision, the judgment of Sir Lancelot Henderson. It's tab 22, page 513 of the authorities, my lady. I should note the decision was handed down in 2022. I could ask you just to read paragraph 77 and 78 over the page. Tab 22.
So can you give the page number again?
513, my lord.
513.
It starts on 513 and runs over the page. My lady, I should just note for completeness that, first of all, that is exactly the same test that this.
Yeah, I recognise it.
Yeah, and in the taxpayer case that my lady referred to, the court wasn't taken to either lifestyle equities or Urenco. So in my submission, this is the test as endorsed by the Supreme Court that this court should apply in determining whether it is entitled to set aside a conclusion of a valueless fact by the First Tier Tribunal. And I should also note, a challenge on that basis is what we were given permission on, so that's the basis on which we put the case. So turning back then to the submissions I was making when we ended yesterday, I was addressing HMRC's submission that the purpose of making a profit without more is not a proper answer as a matter of principle to a tax main purpose test. I'd submitted that if it were, it would render such tests wholly ineffective because it will be rare, if ever, that a person will enter into a tax-motivated transaction without a purpose of making profit or financial gain. And I'd submitted that a conclusion that it was a proper answer would have drastic consequences for both UK domestic and international tax law provisions. And I'd ended by submitting that should, in effect, be clear as a matter of first principles or just simple common sense. And then I foreshadowed that I also submit that the reasoning is strongly supported by the unanimous analysis of the main purpose test by this court in Fisher, and then that was the homework that I set. I'll briefly run through Fisher just very quickly, but by way of background, it's tab 21 in the authorities. But that concerned a UK company which owned the Stan James betting business, and it transferred the business to a Gibraltar company. Both companies were owned by the same shareholders, and as a result of that transfer, they didn't have to pay UK betting duty. I'd note, for your note, I don't propose to go to it now, but paragraphs 16 and 17, the court says that the only way to save the Stan James betting business was to move it to Gibraltar so that it was not subject to UK betting duty. And that's page 446 of the bundle. Now, the case was concerned with the transfer of assets abroad code. Happily, we don't have to look at lots of the issues that the court considered. That's in the Income and Corporation Taxes Act 1998, Part 17, Chapter 3. We are only concerned with the court's analysis of the motive defence. Now, I asked the court to read from paragraph 83. If we could go to page 467, where that is. Paragraph 83, the legislative language is not the clearest. But at 83, the court endorses the analysis of the special commissioners in Carville. The relevant bit of the motive test that they were concerned with was that in section 741B, and the defence, in order to apply, requires that a transaction is bona fide commercial and not for the main purpose of avoiding taxation. Now, I accept it is the main purpose test, but I'm going to submit that the reasoning applies equally to the provision that we're concerned with. You see at 84 that it was common ground that this was a bona fide commercial transaction, and also it was accepted, at least for the purposes of the Court of Appeal, that betting duty was taxation. So you were then effectively left with the question of the main purpose bit of the test. And so if I could, I'm conscious the court may have already read all of this, so we may not need to do it, but if I could just identify the relevant bits that I rely on. Paragraph 86 sets out the FTT's reasoning of the analysis of the main purpose test. And if it's not treading on ground that you've already covered too much, if I could ask the court just to read from capital G of page 468, thirdly, down to over the page to the end of the quote from the FTT. The words I place specific reliance on. The purpose of the appellants, the purpose the appellants rely on as the main reason for the transfer was survival of the business. This is in the context of betting duty avoidance being the means for survival. And this in particular, we doubt whether, in examining whether an avoidance purpose was the main purpose, one can go as far as relying on the consequence of a tax avoidance reason. It cannot be the intention of the legislation that someone who looks beyond the tax avoidance to the consequences of that can be allowed to supplant those consequences as their main purpose. And then at the end they say, this part of the motive defence would, for practical purposes, always be available. In my submission, that is precisely the reasoning that HMRC rely upon in this case. Now, the Upper Tribunal's analysis is set out in paragraph 88. In short, they held, and to take a direct quote, they held that betting duty avoidance was, quote, simply the means of achieving the main purpose of saving the business. So they held that the FTT were wrong. We then have the Court of Appeal's analysis, which is at 90 to 91. In 90, they identify a specific error in the reasoning of the Upper Tribunal, but I'm really placing reliance on paragraph 91. So if I could ask the court just to read 91. In my submission, the first sentence of paragraph 91 can be read as saying, well, this is a question of fact, and the Upper Tribunal was not entitled to interfere with the FTT's conclusion. However, in my submission, the remainder of paragraph 91 addresses the question as one of principle. The Court of Appeal says the two purposes were inseparable, and then particularly the words, the second half of the paragraph, put slightly differently, there can be no question of section 741, the motive defence, applying because a transferor hopes that an intended avoidance of liability to taxation will achieve some further end. Then the end of that paragraph, was someone able to escape section 739 by looking beyond the tax avoidance to its consequences, the motive defence would, as the FTC pointed out, be generally available. That will not have been Parliament's intention. In short, if you could avoid the application of the transfer of assets abroad code by looking beyond the tax to its consequences, then the code would never apply. And that, in a sense, summarises, in my submission, the simple point of principle made by both the First Tier Tribunal and the Court of Appeal in that case, that one cannot look to the consequences of the tax benefit of a transaction in order to say that the tax benefit is not a main purpose of the transaction. And as the Court of Appeal rightly identified, if taxpayers could rely on such an argument, then main purpose anti-avoidance provisions would rarely apply, if ever, because, as the Court of Appeal noted, people very rarely wish to avoid tax simply for the sake of it. Now, in my submission, there is a direct read across from the reasoning in Fisher in the Court of Appeal to this case. You have my submission that the FTT was wrong to hold the sole purpose of BLM was to make a profit from the assignment, when BLM knew that the profit was entirely dependent on and attributable to obtaining the tax benefit under Article 12.1. In my submission, HMRC's argument in this case is actually a fortiori that in Fisher that was endorsed by this court. And that is because in Fisher, in a very real sense, there was a genuine commercial objective that was external to the transaction. Taxpayers were trying to save an ongoing business, and the Court of Appeal was clear that the only way to save the business was to transfer it to Gibraltar. But in this case, in my submission, there is simply nothing beyond the tax benefit. From BLM's perspective, obtaining the benefit of Article 12.1 and generating the profit are simply flip sides of the same coin. Unlike in Fisher, there was no wider commercial aim of the assignment. Now, I accept, of course, that Fisher cannot possibly be binding authority on this court as to the meaning of Article 12.5. It concerned different provisions, and the actual decision of the court was overturned on appeal by the Supreme Court, albeit on a different ground, and the Supreme Court did not address the motive defence at all. It basically held that this wasn't a relevant transfer because the individual taxpayers hadn't transferred the business. It had been a company that had transferred the business. So the Supreme Court doesn't address this question at all. But in my submission, the real relevance of Fisher is that it's a clear instance of this court endorsing the principle behind HMRC's common sense analysis. Main purpose provisions such as Article 12.5 cannot in principle be answered by a finding without more that the sole purpose was to generate profit, where that profit was simply a consequence of the tax benefit that the provision is addressed at. Instead, it was necessary in this case for the First Tier Tribunal, in applying Article 12.5, to go further and ask whether BLM sought to generate the profit with a main purpose of obtaining the benefit of Article 12.1. In my submission, as in Fisher, those two purposes here on these facts are inseparable. It could only have found that to be the case. And so in my submission, in failing to adopt that approach, the FTT misconstrued and misapplied Article 12.5, and that represents a material error in the reasoning of the First Tier Tribunal. I would note that in my submission, the Tribunal's error is compounded by its failure to recognise and take account of the fact that in this case, the assignment would not have occurred at all absent BLM's assumed ability to benefit from Article 12.1. Now, when one looks at the FTT analysis, it focused throughout on the specific price at which the SARD claim was sold, in particular based on the existence of other participants in the market. The Tribunal's reasoning is filled with references to the price at which the transaction happened. I'm not going to take you to all the references. You can see it in 164 sub 1, sub 3, sub 4, 174, 175, 176. It's easiest really just to do a control F of the judgment for the word price. But in my submission, that aspect of the FTT's analysis ignores the fact that the important question in this case is not the specific price of the sale of the SARD claim. HMRC's case does not depend at all on the specific price paid by BLM or the amount of profit that BLM made. Instead, it relies on the fact that the only reason the assignment took place at all was because of BLM's assumed ability to benefit from Article 12.1.
I mean, that may be a function of the fact that you were running a broader set of arguments in front of the FTT, which also attacked Sickle.
But not in respect of BLM.
No, but I mean, it may be a little hard. It may be a little harsh, your criticism.
All I would say, my lord, is I'm referring specifically to the bit of the, because you'll remember the tribunal divides its analysis into 4 sections. 2 of those questions are in respect of points we weren't arguing. But I'm talking specifically about the section dealing with BLM's main purpose. And again, that's all framed in terms of the price.
But there may be a knock-on because the tribunal was looking at both aspects, if I can put it that way.
Possibly, although I would still submit that that's an error in the context of BLM. I'd refer back in that context to the distinction drawn by Mr. Justice Lightman in SEMA that we saw. In my submission, the distinction his lordship drew is right. A tax benefit can be relevant either to the question of the price of a transaction or to whether the transaction happened at all. In my submission, here the tax benefit in Article 12.1 was of absolutely central significance to BLM as to whether the purchase went ahead at all. And you have my submission, it was the only economic basis for that transaction to occur. So in summary, on the facts of this case, the primary facts as found by the FTT, in my submission, the FTT was wrong to hold that BLM's sole purpose of generating a profit from the assignment was a proper answer to HMRC's case under Article 12.5 or a proper application of Article 12.5. That sole purpose was, as a matter of principle, inseparable, in the words of the Court of Appeal in Fisher, from the purpose of obtaining the benefit of Article 12.1, such that the tribunal should, and indeed, well, should have held that Article 12.5 applied. My submission's ground 2 demonstrates a fundamental and material flaw in the tribunal's reasoning and is sufficient without more for this court to set aside and remake the decisions below. It is, in effect, the key error of principle in the FTT's decision. My lord, I'm extremely conscious of the time. My lord will be aware there are 2 other grounds that we rely on. I've dealt with what, in my submission, is the key error of principle. Ground 3, you will have seen in our skeleton argument, identifies 3 specific errors in the reasoning of the tribunal. My submission is that each of those errors is sufficient for this court to set the decision aside. Cumulatively, they are more than sufficient. If one does an exercise of looking at each paragraph of the tribunal's reasoning in respect of BLM and draws a pencil line through that which contains an error, one is not left with very much, if at all, anything at all. And in my submission, the Upper Tribunal's attempts to explain those errors is not successful. Given the time constraints and given that ground 2 is the core question of principle, I am happy, subject to the court having any specific questions about ground 3, to rely on the written submissions in our skeleton argument, if that pleases the court. Of course, if there are any questions from my lady or from any member of the court, I'm very happy to address them. But those submissions do set out, the written submissions set out the position in full and do have references to all the paragraphs in the decisions that we are. I would stress, of course, we do absolutely pursue those grounds, but I'm constrained by time, and to some extent, there's no need to add to them orally, at least subject to any points that my learned friend develops in response. I turn then to the Upper Tribunal's decision, and again, really, and this is a point that my lady and my lord made in the permission hearing, the key point here is that the Upper Tribunal upheld the FTT's decision on the basis that it didn't disclose a material error of law. If the FTT decision was wrong in law, then that, in my submission, is a sufficient basis to set aside the Upper Tribunal decision. So it's right to say that the focus is inevitably on the First Tier Tribunal's decision. Nonetheless, in ground 1, we have identified 2, in my submission, significant further errors of law in the Upper Tribunal's decision, which we've badged the abuse error and the factual starting point error. In my submission, those are pure errors of law. They're not challenges to an evaluative finding. They are errors in the way in which the tribunal construed and understood Article 12.5. And they arise in circumstances where the Upper Tribunal expressly adopted a different analysis of Article 12.5 from the tribunal. You can see that most clearly in paragraph 45 in its decision. As I set out yesterday morning, ground 1 is important for 2 reasons. First of all, it demonstrates that the Upper Tribunal's analysis of Article 12.5 can't be employed as some sort of alternative basis on which to uphold the FTT's decision. And secondly, it also shows why the Upper Tribunal's analysis should be set aside by this court on its own terms, if nothing else, to ensure that that analysis isn't applied in future. Equally, I'm again very conscious of time. Those submissions in respect to the Upper Tribunal are relatively short because they are relatively short points. and it's also not necessary for me to succeed on those points in order to succeed. They're set out in full in the skeleton argument 47 to 45. Again,
So 47 to
47 to 47 to 55. They don't take minus 2 paragraphs. Again, subject to any questions in respect of those submissions, which I'm very happy to address, but I'm conscious I only have 9 minutes. I'm happy to rest on the written submissions. Again, we absolutely continue to rely on those points, but they are set out fully there. If I do have 9 minutes, so if I could just briefly summarise what the grounds are, just by way of overview. The abuse error, as we have termed it, in my submission, involves the fact, or relates to the fact, that the Upper Tribunal, in effect, applied Article 12.5 as if it were a general anti-abuse provision. Their reasoning is, to very briefly summarise, is to say, well, it's an anti-abuse provision. That is, of course, common ground. But in my submission, the Upper Tribunal then sought to apply that provision without regard to the specific abuse it was aimed at, as identified by the contracting states in the text of Article 12.5. In my submission, Article 12.5 is not a general anti-abuse provision. It's a targeted anti-abuse provision in respect of Article 12, and it must be applied by reference to the specific test set out in Article 12.5. Was it the main purpose or one of the main purposes of any person concerned to take advantage of Article 12.5? And in my submission, the Upper Tribunal simply doesn't do that. It says, what's necessary is an abuse. Let's look, well, we'll see it. Let's look at the result of the transaction and say, is there an abuse? And in my submission, that is simply not the right way to proceed in respect of the article. One must apply the article on its terms. One must look at the purpose of the individual entity that one's looking at, which is precisely, you'll recall from my submissions yesterday, what the Court of Appeal did in Vietjet in its second reasoning, the second ground. It said this is not the kind of purpose that Article 11.7, here Article 12.5 is aimed at. So that's the first error in construction, pure error of law, as to the meaning and effect of Article 12.5. The second is what we've badged the factual starting point error. It's a related error, but in my submission it can be seen most clearly at paragraphs 64 to 65 of the Upper Tribunal's decision, and it, in and of itself, discloses two related errors of law in the Upper Tribunal's approach. The first point is that in my submission the Upper Tribunal failed to recognise the fundamental importance of the factual situation subsisting before the assignment to the application of Article 12.5. So in my submission, the Tribunal fails to take account of the fact, in its analysis, that the position absent the assignment would have been that the SARD claim would have been subject to UK withholding tax. Now there's a suggestion, and I addressed the Court on this yesterday in the Upper Tribunal's decision, that HMRC was taking a UK-centric approach, almost as if HMRC's case was that the SARD claim interest should have been subject to UK withholding tax in some sort of normative sense. That is not HMRC's case. But HMRC do maintain that the factual position that subsisted before the assignment is of fundamental significance to determining the main purposes of the parties in entering into the assignment transaction. And that is the specific question posed by Article 12.5. So in effect, in this case, the focus on UK withholding tax is a function of the fact that the benefit is, under Article 12.1, that the interest is not subject to UK withholding tax. In a different mirror case, you'd have exactly the same arguments about, say, if we had a situation where entity in the UK buys from Cayman an Irish source debt, exactly the same arguments would apply. You would still need to look at the position subsisting before the assignment in order to determine the main purposes, but it would be Irish withholding tax. It's not a UK-centric approach. It's just saying that in looking at and determining the purposes of the entities, one must look at the facts that subsisted before the assignment. The related error in that context, in my submission, again, in paragraph 64 and 65 in particular, is that the tribunal incorrectly focused on the result of the assignment of the SARD claim. In fact, it said the correct starting point was to look at the position after the assignment had occurred, and unless there was some sort of abusive arrangement, then Article 12.5 wouldn't apply. It says the result you get is that interest is taxed in Ireland unless there's been some sort of abusive transaction in getting there. Article 12.5 doesn't apply. In my submission, that is simply not the approach that Article 12.5 mandates. It is expressly focused on the main purposes of the parties in entering into the assignment. You can't determine that simply by looking at the result of the transaction. The position, you can't look at it, you can't simply look at the position subsisting after the assignment has occurred. Now, those arguments are set out with full references to the Upper Tribunal's decision in our skeleton argument of 47 to 45. In my submission, those are two errors of approach of the Upper Tribunal to Article 12.5 and further undermine its analysis, in addition to the fact that it upheld the First Tier Tribunal's decision in my submission wrongly. So by way of conclusion, and with 4 minutes left, for all of those reasons, both in oral and now written submissions, I'd submit that the First Tier Tribunal decision involved errors of law of the kind set out by the Supreme Court in Lifestyle Equities. Its reasoning in arriving at its evaluative findings of fact was flawed. The Upper Tribunal decision was wrong in law on the basis that it incorrectly upheld the First Tier Tribunal decision, and it also entailed important errors of law in its interpretation of Article 12.5, those two pure errors of law that I've just summarised. So for those reasons, I submit this court should set aside the decisions below, remake those decisions on the basis set out in HMRC's positive case that Article 12.5 did apply and must be held to apply on the primary findings of fact made by the First Tier Tribunal. My Lord, may I have 1 moment just to check with those behind me?
Sure.
My Lord, unless I can assist further, those are...
No, thank you very much, and that's much appreciated to get it done in the time we'd set you. So, Mr. Woods.
Before I turn to address each of the grounds of appeal in numerical order, I hope it will be helpful to start with a summary of our key points.
Yep.
First, as to ground 1, the Upper Tribunal was right to find that Article 12.5, as an anti-abuse provision, only applies in particular circumstances where it would be contrary to the object and purpose of Article 12 for the beneficial owner of the interest under the debt claim that has been created or assigned to be subject to tax in accordance with the ordinary rule under Article 12.1, i.e. in its state of residence. That is what is entailed in a person having a main purpose to, quote, take advantage, a negative set of words, take advantage of Article 12. Put another way, the question is whether the party had a main purpose of improperly obtaining the advantage of the general rule in Article 12.1. That interpretation of Article 12 is clearly supported by the OECD commentary that I'll come to, and has now been unambiguously confirmed by this court in Vietjet, in particular at paragraph 107, in the judgment of Lord Justice Popplewell, with which my Lord Justice Zacaroli and Lady Justice Aspin agreed, and the relevant parts of the judgment form part of the binding ratio of the case. The learned friend doesn't say that the case was wrongly decided. He doesn't seek to invoke any of the Young and Bristol aeroplane exceptions. He, on the contrary, says it was correctly decided. But as I'll show you, Vietjet is directly inconsistent with the central plank of the learned friend's case. The interpretation I have just identified of Article 12 is fundamentally inconsistent with the central plank of the revenues case, namely that Article 12.5 applies whenever a party to the assignment of a debt claim in a commercial arm's length transaction assumes or expects that it will obtain its ordinary entitlement under Article 12.1 and factors that into the price of the transaction to a material or important extent when buying that claim from a third party in a less preferential tax jurisdiction. Next, and relatedly, the Upper Tribunal was also correct to say, as we submitted below, that the purpose of Article 12.5 is to determine which of the two treaty states should have taxing rights over the interest, with a source in one state where the interest is beneficially owned by a resident of another state. Article 12.5 is intended to prevent parties improperly taking advantage of that bilateral provision. So as the Upper Tribunal correctly said, Article 12 is not, or Article 12.5 specifically, is not to be interpreted as if it were a domestic provision designed to counter a UK tax advantage if the party in question has a main purpose of avoiding UK tax. And although at times learned friends sought to disavow a starting point that one should proceed on the basis that UK source interest should be taxed in the UK rather than in Ireland, at other times that's precisely what he was saying. There is, however, no starting point that UK source interest should be taxed in the UK rather than Ireland. And in this case, the simple fact that Sickle would have suffered withholding tax if the liquidators had not sold the SARD claim in a commercial arm's length deal on the secondary debt market does not mean that BLM should somehow suffer withholding tax instead. Put another way, the unsurprising fact that the price paid for the SARD claim reflected the perfectly legitimate but different withholding tax position of the two parties, and that but for that difference, BLM would have been unable to make a profit when purchasing the claim, does not entail the necessary conclusion that a main purpose of BLM when purchasing that claim was improperly to take advantage of Article 12. Next, in considering the Revenue's core case, we submitted it is very important to keep in mind the Revenue's position in relation to Sickle. In addition to having abandoned their case that Sickle had a main purpose of taking advantage of Article 12 for itself, HMRC have also expressly disavowed any case based on BLM having a sole or main or any purpose of enabling Sickle, the Cayman seller of the debt claim, to take advantage of Article 12. In paragraphs 184 to 185 of the FTT's decision, which I'm about to show you, it held correctly that it was no part of Burlington's purpose when buying the SARD claim to convey to Sickle the economic benefit of Burlington's rights under Article 12.1, even though that was the inevitable economic consequence of the transaction. Could you turn to the core bundle, page 201. We need to look at paragraphs 184 to 185. Sorry. I don't remember the last time I drank out of a blue plastic beaker. Quite a long time ago. The tribunal says this. However, Miss Gibbons' awareness that Sickle had a UK withholding tax issue, which would inform the Sickle liquidator's willingness to sell the SARD claim, and the value at which the Sickle liquidators would be prepared to sell the SARD claim, is not the same as her having a main purpose of solving Sickle's UK withholding tax problems by buying the claim. And on reflection, we think that a more accurate way of construing Miss Gibbons' testimony, as summarised above, is not that she did not take Sickle's tax position into account in assessing the price which the liquidators were likely to be prepared to accept, but more that it was no part of her purpose in entering into the transaction to convey to Sickle the economic benefit of BLM's ability to benefit from Article 12.1. That was an inevitable economic consequence of the transaction which occurred, but BlackRock, at this stage in the Upper Tribunal, since affirmed in the Court of Appeal, demonstrates that it would be quite wrong to regard that fact as being determinative. Instead, it merely formed part of the overall factual matrix in which the main purposes of BLM are to be identified. And then could you just read to yourself the whole of paragraph 185? And I emphasise in particular the words at the bottom paragraph of that page, starting "it was not any part of." Can I then show you what the revenue have said about that part of the judgment? Their current skeleton, I think, is silent about it. And for that, among other reasons, we sought to have included in the agreed supplementary bundle the skeletons below. That was resisted by HMRC, but I don't understand that resistance to be seriously maintained. So if you could turn up our unagreed supplementary bundle and look at the revenues Upper Tribunal skeleton, which is at tab 5 of our unagreed supplementary bundle, and turn to page 87 in the PDF of that bundle.
This is Upper Tribunal skeleton.
Lennifer wants me to take you to something. Yes, I'm grateful to many friends. I'll come back to that.
Footnote 9.
Thank you. So this is paragraph 47. It was HMRC's case before the FTT and remains the case before this tribunal that it was a main purpose of BLM and or Sickle in entering into the assignment of the claim to take advantage of Article 12 for their own benefit. It has never been HMRC's case that either BLM or Sickle had a main purpose of enabling the other party to take advantage of Article 12. As such, the FTT's analysis of question 2 is irrelevant. The FTT was answering questions that weren't before it and aren't relied upon by HMRC in this appeal. My then friend rightly asks me to draw your attention to the same point in footnote 9 of his current skeleton argument. So, given that HMRC have not and do not argue that BLM had any purpose of conveying to Sickle the benefit of its, i.e. BLM's, ordinary entitlement to be taxed in Ireland under Article 12, even though BLM knew that that was an indirect economic consequence of the transaction, it must ineluctably follow that simply having knowledge of that economic consequence cannot mean that Article 12.5 is engaged. Indeed, the revenue's position on sickle exposes what we submit is an essential incoherence at the heart of their core case. It is incoherent to argue that even though it was no part of BLM's purpose to convey to sickle indirectly the economic benefit of BLM's own entitlement under Article 12 to be taxed in its state of residence. Nonetheless, they say, sickle's inability to benefit from Article 12 is somehow still relevant, indeed on Mr. Grimsmead-Stockham's case, determinatively relevant, as to whether BLM had a main purpose of taking advantage of Article 12 for itself. And in our submission, the FTT was completely correct to reject that incoherent case at paragraphs 177 to 178 of its judgment. If we could just turn that up. That is at page 199 to 200 of the bundle, core bundle.
Which paragraphs?
177 and 178. If you just read to yourself those two paragraphs. I will, of course, be coming back to develop my case on the proper meaning of Article 12 and 12.5 in particular in due course later this morning. But that's a summary of what I wanted to say on Article on ground 1. As to grounds 2 and 3, which challenge the FTT's decision, our overall submission is that the FTT's factual evaluation of Burlington's subjective reason for purchasing the claim, which was reached after a thorough consideration of the very detailed documentary and oral evidence, and which plainly took into account the economics of the transaction, was unimpeachable. We submit that the FTT was clearly entitled to find, indeed right to find on all the evidence, that Burlington's subjective purpose was not to take advantage of Article 12, and that its subjective purpose was simply to realise a profit by reference to the difference between its purchase price and the future cash flows which it expected to receive following its acquisition of the claim. Contrary to Mr. Grimsmead-Stockham's core case, the two purposes are not inextricably linked. The First Tier Tribunal well understood that a party's subjective purpose in entering a transaction is to be distinguished from the effects or consequences of the transaction. And, as the case law I will take you to demonstrates, including Kleinwort-Benson and BlackRock and QuickFit, the fact that the price of a transaction is calculated on the assumption that a party is entitled to a particular tax treatment, which it has been accorded by legislation, in this case Article 12.1, does not inevitably mean that that party had a main purpose of taking advantage of that tax treatment. So, the fact that in this case, BLM, which was a long-established Irish resident entity, took into account, as it had to do, its ordinary entitlement under Article 12.1 when agreeing the price it did for the Sard claim through Jeffries, did not entail Burlington having a main purpose to take advantage of the article. And likewise, the fact that Sickle would have suffered withholding tax if the liquidators had for some reason not sold the claim for the best price they could get in the market, and that Burlington was aware of that matter and factored that into the price, does not convert Burlington's ordinary entitlement to benefit from Article 12.1 into an abuse within Article 12.5. And that conclusion is all the stronger given that both parties were aware that there were other participants in the secondary bond market for Libby debt who would also not have suffered UK withholding tax, either as a cost at all or as a permanent cost, and so would have been in a position to pay a price for the SARD claim that was higher than its value to the Sickle liquidators had they retained that claim. Finally, by way of introduction, I'd like to address the consequences of the revenues case were they to be right on their interpretation and application of Article 12. Given that the test under Article 12 is not a sole purpose test, and given that a main purpose means no more than a purpose which has a connotation of importance, those words taken from the judgment of Lord Justice Newey in the TDS decision, the consequences of the Commissioner's case must be that whenever an investment company is resident in a state with a treaty provision like Article 12.5, such as Ireland, and wishes to purchase an interest-bearing debt claim with its source in the other treaty state, then if an important component of the price reflects the difference between the purchaser's entitlement under Article 12.1 to be taxed in its country of residence and a less preferential tax position of the seller, which is resident in a third country, then the ordinary entitlement under Article 12.1 will be switched off. Moreover, in any situation where, like in the present case, there are potential purchasers of the debt claim in the market who can pay a higher price without suffering withholding tax for a variety of different reasons, and they could be UK pension funds, UK corporates with losses to offset, etc., as the Upper Tribunal identified, the person in the position of Burlington will simply be unable to purchase the debt claim at all because it will not be able to compete with the price offered by those other buyers. That clearly would have a very significant and anti-competitive effect on the secondary debt market. My learned friend tried to argue that the impact wasn't really that great, and he said the reason Article 12.5 clearly applied in this case was because the whole of the profit was derived from the parties' different tax positions. We'll come back to that. But when he was pressed for an answer as to where the dividing line was, as you heard yesterday, all he was able to say was, well, each case has to be decided on its own facts. Main purpose tests are notoriously complicated, and they give rise to complex questions of fact. Let's just follow that through. If he's right, it will mean that every time an investment company in a relevant treaty jurisdiction like Ireland is thinking of buying a UK source interest-bearing debt claim on the market, it's going to have to go to its lawyers and seek detailed advice about what Mr. Brimsmead-Stockham has said is a difficult and complex question about whether the dividing line has been crossed depending on a range of economic factors feeding into the commercial deal. But the cautious answer of the lawyers, if he's right, is likely to be, if your knowledge of the 20% withholding tax differential is of any significant importance in the calculation of your profit margin or your decision to go ahead with the transaction, and the reality is 20% a big number, and that's likely to be the case, you would be well advised not to purchase the debt claim at all, because the revenue are going to argue that's an abuse, which switches off your ordinary entitlement to be taxed in Ireland under Article 12.1. So for those reasons, my lady and my lords, the revenues approach would, as the highly experienced and specialist FTT and Upper Tribunal in this case well recognised, have a very significant, adverse, and I would say anti-competitive impact on the commercial debt market, which serves to further demonstrate why the revenues approach to the interpretation of Article 12.5 cannot be right.
Can I, with some trepidation, just voice a concern I have over this aspect of the case?
Yes.
I'm not sure this goes anywhere, but there are two aspects to this test: what taking advantage of means and what a main purpose means. Now, it's clearly in the revenue's interests generally to say to advance its case on taking advantage of. I understand that. It's also in the abstract in the revenue's interest to widen the test of main advantage.
Yes.
Sorry, main purpose. If, however, main purpose had a much narrower interpretation in the context of this treaty than it does in domestic law,
yes,
the consequences, the dire consequences,
might not be as dire.
Exactly.
Yes.
But you're not arguing for that.
No, and it was common ground below, and I noted my lady's thought yesterday about whether that was the right approach. It's been common ground throughout, but consistently with Article 3.2 of the treaty, of this treaty, not the Vienna Convention, but this treaty, the concept of, or the interpretation given to main purpose tests in UK law can be relied upon or is relevant to how that main purpose test is to be understood in the context of a bilateral treaty. We did look at whether the position was the same in Ireland, and in broad terms, and this is now a long time ago because we looked at it before the FTT hearing, the position is broadly the same. So in circumstances where two parties to a bilateral agreement have similar jurisprudence on how main purpose is to be understood, that supports the common ground that I've just identified.
Yes, I mean, part of the reason I raised that, a large part of the reason is picking up of the main purpose concept in the OECD, which means that it may well be adopted by in treaties to which neither the UK
have similar
nor Ireland, which for understandable reasons might have similar domestic jurisprudence, but this test might be applied in very different circumstances where the UK is not a party.
Well, I recognise that, my lady, and I suppose it's conceptually possible, although unattractive, that in another bilateral treaty where the concept of main purpose has in one or both of the treaty states a very different meaning, a different meaning maybe end up, consistently with Article 3.2 of the treaty, end up being ascribed to the main purpose concept.
Yeah, well, it's really where I question whether 3.2 is really getting at ordinary words, if you like.
Well,
rather than, for example, technical references to different types of tax or something of that nature.
Well, one thing I was going to say in answer to my Lord Justice Zacaroli's observation is that although it's conceptually possible to draw a line between main purpose and take advantage, the better approach, which is the one that the Upper Tribunal took, which is to look at the provision as a whole in light of how it is described, particularly in the OECD commentaries, which I'm going to come to.
Which rather argues towards main purpose within that whole concept, not necessarily having the domestic interpretation.
Yes.
But our problem is that we are being required to decide what taking advantage of means within that concept. But in the context of a dire warning of the consequences based upon a broad meaning of main purpose.
Yes.
There's a risk of getting it wrong because we're being forced down a road which creates dire consequences.
My Lord, I understand, but for my purposes, and this sounds a bit opportunistic, but I'm going to make the point anyway, it doesn't really matter whether we win because main purpose has a narrower meaning than the wide one relied upon in domestic jurisprudence, or that wider one. In either event, given the negative connotation of take advantage, which was confirmed in Vietjet and which has been confirmed, or rather is supported by the OECD commentary, in my submission, I win either way. There would be no basis for interfering with the FTT's conclusion that there was not a main purpose to take advantage of Article 12.1. I recognise that doesn't really assist this court in giving guidance for the general world, but for notwithstanding, I watched with interest the live stream video of the permission hearing, unsurprisingly, at which one of the points made by my learned friend was that the world was waiting with, he didn't use this language, but bated breath for the Court of Appeal's judgment in this case to give guidance as to how this treaty provision is to be interpreted. But that may be right, but for present purposes, it's the function of this court to give guidance in England and Wales, not necessarily the function of this court to give guidance as to how this is to be interpreted in other jurisdictions, at least not outside of the UK treaty.
Understood, but it still remains somewhat uncomfortable.
I
in
recognise
circumstances where this is not. Yes, the UK revenue authorities might have promoted this sort of text that's now in the commentary, but the fact is it's there and it's probably used much more widely.
My lady, I understand. I don't think there's anything more I can say on that point unless I'm asked to. Can I now turn to ground one of the appeal? And I'm going to do this in 3 parts. First, by identifying the key passages in the Upper Tribunal's judgment where it considered the purpose of Article 12.5 as a whole, and Article 12 as a whole, and Article 12.5 as part of that. Then I'm going to take you to the decision in Vietjet and the OECD materials, which we say clearly support the Upper Tribunal's interpretative analysis. And then I will come to address what Mr. Brimsmead-Stockham called in his written and oral submissions the abuse error and the factual starting point error. So, if we can turn, please, to the Upper Tribunal's judgment. It's at tab 8 of the core bundle, starting at page 89. Can we go straight to paragraphs 45 to 47? I will come later on to address Mr. Brimsmead-Stockham's submission that the FTT and the Upper Tribunal came to very different interpretations of Article 12.5. I don't accept that. But I do accept, indeed it's clear, that the Upper Tribunal took a different approach into how it conducted the interpretation exercise. We can see that from paragraph 45 and 46. Unlike the FTT, who started with the ordinary meaning of the words, we start our analysis by considering the object and purpose of the treaty, having regard to the relevant OECD and other materials. That, of course, is not a substitute for considering the text or the various textual points that the parties make. However, it will enable us to put the text in context. And then there's a reference to what Lady Rose said in the Cornerstone and Compton Beecham Estates case, where she deprecated an approach, even in a domestic legislative context, of starting with dictionary definitions, which is where my learned friend started, before considering the context and purpose of the statutory scheme, noting that that accorded with an earlier judgment in Bloomsbury International, leading case on statutory interpretation, at least in the domestic context, where Lord Mant had said the notion of words having a natural meaning isn't always very helpful, and certainly not as a starting point, before identifying the legislative purpose and scheme. A provision similar to Article 12.5 of the treaty is not included in the OECD Model Convention, but the commentary on the Model Convention, ... does contain material that in our view should be taken into account. In the following paragraphs of the Upper Tribunal's judgment, it goes on to consider those OECD and other materials, and I'm going to come back to them. But having done that, its conclusions on the object and purpose of Article 12 and the meaning of Article 12.5 in particular start at paragraph 61. We consider that the core purpose of Article 12 of the treaty is simply to determine which of the two treaty states should have taxing rights over interest with a source in one of the states where it is beneficially owned by a resident of the other. To use Mr. Brinsmead-Stockham's language, it's a distributive, is that the right word? Article. The UK-Ireland Treaty has expressly provided that as between the UK and Ireland, unless Article 12 applies, it's the resident state alone that has the taxing rights in relation to interest arising in the source state, so long as the person in the resident state beneficially owns the interest. And you'll see, not that it's necessary for my purposes, but you'll see in the commentary that sometimes the insertion of a beneficial ownership clause is referred to in the commentary as being one of a range of anti-abuse provisions that may be included in a treaty. HMRC submitted before us that the purpose of Article 12.1 is to facilitate and encourage lending between the UK and Ireland by seeking to eliminate the risk of double taxation on such loans. Well, how even that purpose could be consistent with the anti-competitive effect I identified earlier is difficult to see. But anyway, we are prepared to accept, said the Upper Tribunal, that this is a purpose of Article 12, but we don't consider it's the only purpose. In any event, this appeal concerns the means by which the contracting states have sought to achieve the overall objective of Article 12, and they've done so by giving the resident state, here Ireland, the sole taxing rights over interest unless Article 12.5 applies. Then, if we can turn to paragraph 64, in determining whether there has been an abuse of the UK-Ireland Treaty in the case of both the assignment of the SARD claim, the question has to be answered by reference to both contracting states. It is, as BLM submits, wrong in principle to answer the question as if Article 12 proceeds from a starting point that interest on the SARD claim should be subject to UK withholding tax, since that was the pre-existing position when Sickle held it. Article 12 is not to be read as if it were a provision contained in a UK statute concerned only with UK taxation, and as providing for a UK tax advantage to be eliminated if a party had a main purpose of avoiding UK tax. In our view, the correct starting point is the proposition that unless there is an abusive arrangement falling within Article 12.5, BLM as a resident of Ireland and beneficial owner of the claim is to be taxed only in Ireland on the post-administration interest. The question, therefore, is whether there is something abusive in the particular circumstances of the case for Ireland alone to tax interest beneficially owned by a company resident in its territory. And we say that is completely correct. And then paragraph 67, which we also with respect say is correct. We accept that as a tribunal of fact considering Article 12.5 may well consider it relevant to determine the extent of a person's knowledge of the treaty, including whether a party has taken steps to disguise their knowledge or avoid obtaining specific knowledge of its provisions. But those matters would simply form part of the factual inquiry to determine whether a person concerned in the creation or assignment of a debt claim has a main purpose of improperly taking advantage of Article 12.1. Can I show you Mr. Brinsmead-Stockham and Mr. Hellier's skeleton argument in this appeal, with that in mind? It's paragraph 53.2, page 38 of the core bundle. he says at paragraph 53.2, further to paragraph 1 above, instead of applying the terms of the treaty, at various points the Upper Tribunal read additional words into Article 12.5 without any proper basis. For example, and then he cites the words I've just read out. So by inserting the word improperly, says the Revenue, the Upper Tribunal incorrectly added the underlined word into the terms of Article 12.5. But as is clear from the OECD commentary and from this court's decision in Vietjet, that is precisely the correct interpretation of Article 12.5. And with that in mind, can I go back now, please, to Vietjet? Authorities Bundle, tab 33. I've had a Lord Justice Sedley moment. All of my files have split. Can you just give me a moment? Lord Justice Sedley used to have a set of rules about bundles, one of which was they'll always come apart when you most need them. I don't remember any of the others.
It simply may be a function, regrettably, of the volume of paper that is normally put into lever arch files.
I suspect also a function of my clerk's over-enthusiastic use of the trolley.
Did you say tab?
It's 30.
30. I thought that was the Lord said. Just said a moment. Wrong tab number.
As Mr. Brimsby-Stockham correctly said, this case has been refused permission to appeal to the Supreme Court by the Supreme Court, although he also said permission wasn't even sought on the relevant point for today's purposes. Anyway, this was, as has been explained already, a commercial dispute, as my Lord Justice Zacaroli will recall, between Vietjet, who was the operator and lessee of 4 aircraft, and Fitzwalter Aviation, which was the assignee of rights under various loan financing arrangements relating to the 4 aircraft. One of the issues in the dispute concerned whether Fitzwalter was a person who, as required by the contract, had the benefit of a double tax treaty with Japan, such that no withholding tax would have been levied on the payments of interest under the loans. Can we just pick it up, please, in the judgment of Lord Justice Popplewell at paragraph 15, page 769. I just want to introduce the issue. In relation to the NEO aircraft, that's the new engine option aircraft, and there were 2 new engine option aircraft and 2 CEO option aircraft, which is current engine option. I don't think it matters what the difference between new and current meant. There are 2 further issues as to whether FWA was a permitted assignee by reference to the definition in clause 9.13 of the loan agreements, which required it to be someone benefiting from the double taxation treaty with Japan. Those issues which turn on an interpretation of the relevant treaty and factual questions about FWC's business. FWC was a UK incorporated part of the Fitzwalter Aviation Group.
Yeah, as I understand it, it was set up to acquire these loans.
Yes. Yes. Were determined by the judge in favour of FWA in answering questions 5 and 6. Vietjet challenges those conclusions in grounds 3 and 4 on this appeal. Can we then turn to page 791? No, 790. Starting at the foot of the page, grounds 3 and 4. These grounds apply only to the NEOs and the wording defining a qualifying lease in clause 9 of the loan agreements, which for the reasons I have identified don't apply to the current engine option loans. Grounds 3 and 4 focus on the requirement in subparagraph 3 of clause 9 that such a new lender must be one which benefits from a double tax treaty with Japan, so that no withholding tax will be levied in relation to payments of interest, being qualified as an entity that can receive such interest free of withholding tax under the treaty. FWC is incorporated in England and Wales. There's a double tax treaty between the UK and Japan. The issue is whether FWC benefited from the DTT such that no withholding tax will be levied in Japan in respect of interest payments. One of the things that Mr. Brinsmead-Stockham said allowed you to put this case to one side so far as he was concerned was that on the facts, by the time the dispute arose, there was no question of FWC obtaining any benefit under the treaty. That is not how the argument proceeded. So, paragraph 70 says, I would observe that by the time FWC took an assignment of the loans, which is the relevant point in time at which to determine whether it fell within the definition of a permitted assignee, there had been a default and the loan had been accelerated. And the limited recourse provisions meant that it would have to look to the security to recover the amount due. There was no question by that stage of the borrower making periodic interest payments under the loan to which the qualification as a beneficiary of a treaty for withholding tax purposes might be relevant. So that's the bit that Mr. Brinsmead-Stockham was focusing on. However, the judge goes on to say it's true that the loan agreements provided for default interest so that the amount of security which the lenders through the security trustee might realise before having to account for such surplus of the borrower would be affected by the amount of such default interest due, that it was never going to be paid by the borrower and no question of paying it with or without holding tax would arise. However, the argument before us proceeded on the basis that what mattered, at least for ground 3 and you'll see for ground 4 too, was whether FWC would have been entitled to receive interest payments under the loan, net of withholding tax under the treaty, which the judge held that it would. So the argument and the analysis proceeded on the assumption that what mattered is not whether FWC would have or did obtain the benefit, but whether it was permitted to under the terms of the treaty. Paragraph 71. The purpose of the treaty appears from its recital. Well, could I ask you to read, for context, paragraph 71 through to 73, perhaps in due course rather than now. But the key point is that ground 4 concerned whether FWC was disentitled to the Article 11.1 treatment, which is the analogue of the Article 12.1 treatment in our case, because it fell within Article 11.7 of the Japan Treaty, which is the analogue of Article 12.5 of the Ireland Treaty. Then there's a discussion about ground 3, which concerned an issue that's not directly relevant to our case, namely whether FWC was an exempt resident under Article 22.5. That obviously doesn't arise in our case, but nonetheless, the Court of Appeal gave the perhaps most recent guidance on the proper interpretation of double tax treaties by reference in large part to my lady's judgments in various other recent Court of Appeal decisions. And that can be seen at the foot of, starting at the foot of 793, under the heading 1, Interpretation. If you then go up to the top of page 794, and in due course I'd ask you to read, or in my lady's case and my Lord Justice Zacaroli's case, reread paragraphs 78 through to 84. And that includes, as you will see, consideration of the recent case law on interpretation of tax treaties, including in the GE Financial case, my lady's judgment, and the Royal Bank of Canada case, again my lady's judgment, which, as Lord Justice Popplewell observed at 79, was subsequently upheld by the Supreme Court, Lady Rose, in that decision, the Royal Bank of Canada decision. But for present purposes, can I focus just on 3 passages? The first is what was said in the Czech Republic and Diang Human case in paragraph 80, where the court referred in turn at the top of page 797 to what Lord Kerr in Muhan said was the proper approach. So picking it up at the top of page 797, it would be wrong to read Article 31, that's of the Vienna Convention, as reflecting something like the so-called golden rule of brackets domestic statutory interpretation, where one starts with the ordinary meaning of the words and then moves to the other considerations only if the ordinary meaning would give rise to absurdity. That is not international law. The International Law Commission made clear in its commentary on the draft Vienna Treaty that in accordance with the draft treaty, that in accordance with the established international law which these provisions of the Vienna Convention codified, such sequential mode of interpretation is not contemplated. Then he explains why. And then paragraph 83 at the foot of that page, the holistic exercise required by the Vienna Convention means that starting with a supposed natural meaning is often not a helpful approach. And then there's a reference back to the Bloomsbury case, which I referred to and the Upper Tribunal referred to earlier. If you could just read paragraph 83 and the first sentence of paragraph 84. And those paragraphs which express a general approach to the interpretation of tax treaties are entirely consistent with the approach taken by the Upper Tribunal in this case. But of even more direct relevance to this case is how this court dealt with ground 4. Can we pick it up, please, at page 807? Paragraph 103 sets out Article 11.7 of the UK-Japan Treaty, which is in the same terms as Article 12.5 of our treaty. Paragraph 104 sets out how Vietjet sought to argue that the prohibition was engaged. Paragraph 105 sets out how Mr. Justice Picken had rejected the argument in the High Court. Then paragraph 106, which is part of the ratio of the case, says, I don't find it necessary to deal with the arguments addressed by Vietjet to that reasoning, nor FWA's responsive arguments, because there are two of FWA's arguments which are fatal to Vietjet's reliance on Article 7 and which don't depend on it. The first is that taking advantage in Article 11.7 does not mean simply taking the benefit of Article 12, Article 11 of the DTT. But that is precisely the interpretation that Mr. Brimsmead-Stockham repeatedly advanced below and to this court. He said it just means having the benefit, and that the Upper Tribunal was wrong, he said, to insert the word improperly. Carrying on, Lord Justice Popplewell said, it means doing so contrary to the object and purpose of the treaty. In other words, it's an anti-abuse provision. That's clear from the object and purpose of the treaty and from the OECD commentary. As to the object and purpose, it's to attribute the right to tax persons in its state of residence or state of source in accordance with its detailed provisions, and as Mr. Peacock put it, to avoid double taxation and non-taxation. Article 11 applies that purpose in respect of debt income. If a taxpayer is taking advantage of the article in the sense that Vietjet contends, the words bear, of simply taking the benefit of Article 11, which is exactly Mr. Brimsmead-Stockham's position, that would involve it paying tax in the state which Article 11 provides for. If so, to treat Article 11.7 as preventing it from doing so would be the very opposite of giving effect to the object and purpose of the treaty. It would disapply the treaty and so subvert the allocation of taxing rights and benefits which the contracting states have thereby agreed, to which we say, I don't know how to say amen without sounding sanctimonious, but amen.
I don't think you can. Was it?
I walked straight into that.
Is it? Am I right in remembering that there was no issue in that case about taking advantage in the sense of obtaining an economic benefit by being taxed in the UK rather than Japan? That simply wasn't an issue in that case.
I don't think it was.
No, because it was about taking advantage for the purposes of a contractual provision.
Yes.
Yes.
I mean, whether there's a material difference between the two, I respectfully say there isn't.
Yeah.
But that, in other words, that's not a reason to distinguish the court's reasoning in the case. I think Mr. Brimsley-Stockham says it is. He nods enthusiastically.
Yeah.
But I shake my head equally enthusiastically. Then there is a reference to 2 paragraphs of the OECD commentary, which I'll come to in their original source in a few moments. Then there is an express setting out of the very paragraph on which Mr. Brimsmead-Stockham yesterday pinned his colours, namely 21.4 of the commentary. At paragraph 21 and following, the commentary addresses other forms of abuse, still under the rubric of the heading improper use of the convention. And then it includes the following, and I'll come back to paragraph 21.4. And they say, Mr. Justice, Lord Justice Popperwell says at paragraph 112, this is clearly the source for Article 11.7 of the Japan Treaty and is in terms explained as an anti-abuse provision in a section of the commentary addressed to meeting improper use of the convention. It is therefore to be interpreted as catching and only catching abusive conduct, that is to say, taking advantage of Article 11 as a main purpose, where that is contrary to the object and purpose of the treaty in its application to the taxpayer. And then he explains why that didn't apply in this case. I've already, by referring to shaking my head and nodding, Mr. Maloney-Friend's nodding his head, made my point about why Vietjet is not distinguishable.
Can you just go back to paragraph 109, which you didn't dwell on? You, I assume, endorse what is said there as an example. How do you relate that to the sort of examples we've been considering in this case, our case? I mean, does it have any relevance to the fact pattern of our case, as an example?
I don't think it does, my lord. I mean, you'll see when we get to the commentary and the OECD conduit report, which we haven't yet looked at, and the FTT's correct analysis, that the classic ingredient which has to be present in order for an anti-abuse provision such as Article 12.5 to be engaged is where the seller, or the notional seller, or the parent, here Sickle, resident in the non-preferential jurisdiction, here Cayman, somehow, in one way or another, retains an indirect economic benefit in the debt claim which has been transferred, assigned or sold. Now, there are many examples in many different ways of how abuse may arise, none of which come anywhere close to the facts of our case. But I'm cautious about being drawn into how helpful paragraph 109 is one way or the other to the facts of our case.
Okay.
Given that Mr. Brimsmead-Stockham doesn't suggest that Vietjet is wrongly decided, indeed on the contrary, strictly speaking, I don't need to go back into the OECD commentary, but I think given the importance of this case, it will be helpful to do so. So can we start, please, at...
I'm just wondering whether actually the transcript writer
Yes.
needs
Now
a
may be a
break
good time.
before you go into the OECD and gets stuck into that, or whether the transcript writer is happy to carry on.
I wouldn't mind a short break.
Sure. Okay, let's do that. Just 5 minutes.
All right, if able.
feel very infantile drinking out of a blue plastic beaker.
Whether it's
as able.
To save you having to listen to my voice more than is strictly necessary, could I ask you to read to yourself at tab 34, picking it up at page 847, all of paragraphs 7 through to paragraph 9.5. Then I'm going to make a couple of submissions. So it's the bottom half of 847 through to the first half of 849.
Are we looking at the? We're looking at the 2014.
We're looking at the 2015 commentary, although I'll take you to the later commentary in a few minutes. So, as you can see, the commentary discusses ways in which abuse of tax provisions can be countered. Broadly speaking, one by domestic provisions, one by including provisions in a treaty. But the parts on which I wish to focus for present purposes is at 9.3 and 9.5. 9.3 is at the foot of 848. Other states prefer to view some abuses as being abuses of the convention itself, as opposed to abuses of domestic law. These states, however, then consider that a proper construction of tax conventions allows them to disregard abusive transactions, such as those entered into with the view of obtaining unintended benefits under the provisions of these conventions. That interpretation results from the object and purpose of tax conventions, as well as the obligation to interpret them in good faith. See Article 31 of the Vienna Convention. Under both approaches, therefore, it's agreed that states don't have to grant the benefit of a convention where arrangements that constitute an abuse have been entered into. And then this salutary guiding principle. It's important to note, however, that it shouldn't be lightly assumed that a taxpayer is entering into the type of abusive transactions referred to above. A guiding principle is that the benefits of a double taxation convention should not be available where a main purpose for entering into certain transactions or arrangements was to secure a more favourable tax position, and obtaining that more favourable tax treatment in these circumstances would be contrary to the object and purpose of the relevant provision.
As I read that, it's a general guidance for how to approach double tax convention.
Yes, I would agree.
Not even if there wasn't the equivalent of Article 12.5.
I would agree with that, my lady, but
Even though it seems to more or less, well, it's got some language heavily overlapping.
so my friend is interrupting me. Sorry, what do you mean?
I was just saying, if you could look at 9.6.
I was going to. I would agree with that, my lady, but what I'm going to come on to say is that when we get to paragraph 21.4, on which my learned friend placed so much reliance, it remains, as Lord Justice Popplewell correctly identified in Vietjet, still under the general rubric of improper use of the convention. And so in my submission, the guiding general principle in paragraph 9.5 not only applies generally, but also when interpreting the specific provisions such as that contemplated in 21.4. That's essentially what Lord Justice Popplewell...
Okay, and to remind me, he did cover, I know he covered 21.4.
He also...
He did refer to 9.5.
Can I... he
You
highlighted...
don't need to take me back.
Not only did he cover it, he set it out word for word and underlined the relevant bits I've just been highlighting.
Thank you. Right.
And said in terms, it's all got to be 21.4 was under, as his language, not mine, the rubric of improper use of the convention. And my friend wants me to read you out paragraph 9.6. Could you read 9.6 and 10, please? Because 10 also shows you what I said earlier, which is that inclusion of the concept of beneficial owner is also part of the anti-avoidance armoury that may be adopted. And there are various examples of how treaties may be abused, such as through permanent establishments. And then at paragraph 11, there's a reference to the conduit report, where the commentary says a further example is provided by two particularly prevalent forms of improper use of the convention, discussed in two reports from the Committee on Fiscal Affairs entitled Double Taxation Conventions and the Use of Base Companies and Double Taxation Conventions and the Use of Conduit Companies. I'm going to come back to that report. But then if we go straight to page 859, this is still under the, we haven't got all the intervening pages. We do have all the intervening pages. This is still under the general rubric of improper use of the convention. I mean, you can see, A, that's what the Court of Appeal has found in Vietjet. B, it's, sorry, not B, and it's right. Of course it's right. If you look at, it's a bit of font analysis. If you look at the font in page 847, there's a bold, non-italicized heading, improper use of the convention. Then if you turn through, there are various subheadings in slightly smaller font italics, such as conduit company cases on page 851, and the heading on page 857, and the heading on page 858, and the heading on page 859 that is above the very paragraph we were looking at before. My children accuse me of being a font pedant, but sometimes it pays to be that. Can I then deal with Milena Friend's specific submissions on paragraph 21.4? He said that his case was supported by the opening sentence of that paragraph. But as my lady correctly observed, that can't be right. That sentence cannot purport to set out or explain in full the meaning of the indented passage, which is the analogue of Article 12.5 in our case. For one thing, it refers to transactions having been entered into for the main purpose of obtaining these benefits, rather than, as the passage, the sample passage in indented text then refers to, and as has been incorporated in our treaty, the main purpose or one of the main purposes of any person concerned. So that can't purport in the first sentence to be a full explanation of the scope of the indented passage. And secondly, as I've already now made clear, that paragraph 21.4 still has to be read in light of the guiding principle set out in paragraph 9.5 that I took you to earlier. Nothing in that first sentence of paragraph 21.4 displaces or calls into doubt that guiding principle. Can I also deal with my learned friend's ambitious submission that because neither the United Kingdom nor the Republic of Ireland have entered a reservation to that sentence of the commentary, they can be taken in some binding way to have agreed its authoritative interpretative effect? And there are two answers to that. First, there is no case law or other authority at all for that novel proposition of interpretative law. Rather, the correct position, as my lady said in argument yesterday, is that set out by Lord Briggs in the Fowler case, which I'll give you the page reference for. It's Fowler, page 404 of the Authorities Bundle, paragraph 18, where he said that the commentaries are to be given such persuasive force as the cogency of their reasoning deserves. Secondly, in this case, there would have been no need for the United Kingdom or the Republic of Ireland to enter any reservation about the first sentence of paragraph 21.4 for precisely the reasons I've already given. That sentence doesn't purport to set out a full explanation of the provision, nor qualifies the guiding general principle in paragraph 9.5. Can I next, and for completeness, take you to the 2019 commentary at tab 36, into which I hope you have inserted the additional pages handed up on day one. The essential position in the 2019...
Sorry, just interest. You call this 2019.
Only because that's
the difference in the year is it's a 2019 commentary on a 2017 version.
Yes, my lady.
If I might ask this, my lady, I think they're published in 2019, but it's the 2017. It's the 2017 commentary. So the 2019 date is just the date of publishing.
I see. So should we call is the correct label for the previous one 2014?
Yes, my lady. It's the 2014 commentary, but it's published, and you see it's published in 2015.
I confess I just simply use the year of publication as the shorthand. But I don't quibble with what the learned friend has said.
Thank you.
But anyway, my main point is that the position remains fundamentally the same. So paragraph, as we will see when we look at the history pages, paragraph 54 corresponds to the old paragraph 7. I'm not going to take you seriatim through each of the paragraphs to show which it corresponds to in the earlier version. But I do want to highlight...
Sorry, you said paragraph 54 corresponds to...
Paragraph 54 corresponds to the old paragraph 7. And that's what's stated in the history pages that I'll take you to in a minute. Paragraph 57 states as follows. Paragraph 9 of Article 29, which I'm going to come to, and the specific treaty abuse rules included in tax conventions are aimed at these and other transactions and arrangements entered into for the purpose of obtaining treaty benefits in inappropriate circumstances. Not just obtaining treaty benefits, but obtaining treaty benefits in inappropriate circumstances. And then the guiding principle remains in this latter guidance as set out in paragraph 61 over the page. Important to note that it shouldn't be lightly assumed that a taxpayer is entering into the type of abusive transactions referred to above. A guiding principle that the benefits of a double taxation convention shouldn't be available where a main purpose for entering into certain transactions or arrangements was to secure a more favourable tax position, and obtaining that more favourable treatment in these circumstances would be contrary to the object and purpose of the relevant provisions. That principle applies independently from the provisions of paragraph 9 of Article 29, which merely confirm it. And I'm going to take you to that in a minute. So if you turn forward, I hope you have immediately after, you should have page, if you look at the pagination in the bottom right-hand corner, you should get to a smaller font section starting at C191.
Yeah, we would have handed that up.
Yeah, that's separate.
Yeah.
And that just, and I'm not going to take time to go through it, but that just shows you how each of the new paragraphs correspond to the old guidance. And then we get, if we may, to page 889 of the authorities bundle, which is model Article 29, called Entitlement to Benefits. Could I ask you to read, not the substantive articles themselves, but footnote 1 at the bottom of page 889. Then over the page, please, at the foot of page 890 is Model Article 29.9. Now this is in a different form to the treaty provision we are concerned with in this case, because this is now the principal purpose test, which is expressed in different language. Nonetheless, you can see through the concluding words of that new principal purpose test the same guiding principle coming through, which is that you have to ask whether granting the benefit in particular circumstances is or is not in accordance with the object and purpose of the relevant provisions of the Convention.
Okay, this is the 29.9 that's referred to in the commentary.
Precisely so.
Yes.
So whether under the old directly relevant provision and guidance, or under the later guidance, the guiding principle remains as I have identified it, or rather, perhaps more accurately, as the OECD has identified it. Then can I take the court, please, to the conduit report, which is at tab 35, and ask you to read paragraphs 1 through to 4.1, which is about direct conduits.
I'm sorry, I've just missed your reference.
So it's tab 35,
Yep.
starting at page 863.
Yep.
The whole of page 863 and the very first small paragraph on page 864.
Okay.
Then in the following paragraphs, there are various examples given which the tribunals in this case referred to in terms that I'll come back to. And then if you could just please look at paragraph 9, the foot of page 866 and the top of page 867. Can I, with that all in mind, then address Mr. Brimsmead Stockham's submission to this court as he made it below as well, that there's fundamentally no difference between our case and a conduit company case, a conduit case. And the answer I would give is to say that the FTT got it completely right when it rejected this aspect of Mr. Brimsmead Stockham's submissions. If you turn, please, to paragraph 196 of the FTT's decision, which I don't think we've looked at yet. At least not in the court. Page 203 of the core bundle. So paragraph 196 refers to Mr. Brimsmead Stockham's assertions to the effect that the transaction which is the subject of the appeal was no different from the cases of conduit companies or treaty shopping. He submitted that this was because when viewed in economic terms, Sickle was taking advantage of Article 12.1 through the price which it received for the SARD claim. If you could then read paragraph 197 through to 200. It's true that at that stage, Mr. Brinsmead-Stockham's argument was being run by reference to Sickle at a time when he was still maintaining the revenues case that Sickle had a main purpose to take advantage of the treaty. But the First Tier Tribunal's analysis of what the difference was between this case and a conduit case remains relevant. In particular, given the point I made in opening, that the revenue have disavowed any case that it was part of Burlington's purpose to convey to Sickle the economic benefit of Burlington's own entitlement to be taxed in Ireland in accordance with Article 12.1.
And you say that, presumably you say that Mr. Brinsmead-Stockham's wrong to characterise what's happened in his Appendix 1 as the sharing of the benefit of the double tax treaty.
Absolutely. I mean, it suits his purposes to do so. That's not the way in which the FTT analysed it, and it was right not to analyse it in that way. The benefit, or rather the position, everyone keeps on calling it a benefit. It's a distributive article. Benefit, or somehow seems to confer the idea that you're getting something you wouldn't ordinarily get. As I'm going to come on to something, that's the wrong starting point. The ordinary position under Article 12.1 is that you are taxing your state of residence on source income derived from the other state. So you don't start from the starting point that Mr. Brinsmead-Stockham does. It's to say, here's the UK withholding tax that should have been charged, and you split the difference in some way. That's not how it works, as the FTT well understood. And with that in mind, can I...
Well, just thinking about this a bit more, classically you think of tax avoidance as, in a comparative sense, as in you've improved your position.
Yes.
Compared to the position you would otherwise be in.
Yes.
Here, the revenue need to say that the improvement is by comparing the position of Sickle with the position of BLM.
But they can't.
I'm just trying to... I think I'm going back to your point about incoherence earlier, actually, but I'm trying to understand it a bit better. You can't... If you look at BLM by itself, it's a long-established Irish resident, and that's what the treaty says.
The treaty says that such a person is entitled to be taxed in its source of, in its state of residence.
And
so there's no a priori.
On the face of it, it's not the fact that it's making use of Article 12 is a sort of normal consequence of the fact that it is an Irish resident.
Exactly.
Owning a debt claim.
Exactly.
The abuse using it in the smallest a word, as in the way that Mr. Brinsmead-Stockham would use it, can only lie in the distinction between the position of Sickle and the position of BLM.
Yes.
But we're now in a situation where Sickle's purposes are ignored. We're not looking at Sickle's purposes, or as you say.
Well, there's two things. One, the revenue's abandoned their...
tried to do in relation to Sickle.
The revenue's done two things. One, it's abandoned its case that Sickle had a main purpose of taking advantage of Article 12 for itself. And that is because it recognises the difficulty in that case in circumstances whereby what I called below the deal date of the 8th of February, it didn't know that its counterparty through Jeffreys was going to be Burlington, an Irish resident. But it's done more than that. It's expressly disavowed any case that it was any part of BLM's purpose to convey to Sickle a benefit derived from what I'm going to call the withholding tax differential.
Can I just take it in stages?
Yes.
Because I think it's implicit in your analysis of what taking advantage means.
Yes.
That it's really only applies where a benefit, using that term loosely at the moment, is accruing to a company in a jurisdiction which doesn't have the advantage of a double tax treaty like Ireland has. So it's
that is certainly the principal circumstance in which I say Article 12.
Well, it may be worth exploring on your analysis whatever else would fit within it. But
yes, I anticipate we might have to do that, so I've thought of some answers.
Good, but let's take that as a starting point. If Sickle had been fully aware that BLM could only economically justify this transaction because of its reliance on Article 12.1, Sickle knew it couldn't do the same.
Yes.
And entered into a transaction where it sold the debt for 90, being the split in the difference between, say, 180.
Yes.
Economically, that does result in the part of the value which represents what would have been withholding tax being shared with Sickle.
Yes.
Would you accept that you wouldn't? And
No.
why is that not?
Well,
within your
part of me wishes to invoke St. Paul and say, "Sufficient unto the day is the evil thereof."
I think we're getting back to where we were before.
Yeah. But the real answer is, even in that situation, I wouldn't accept that was an abuse, because as the First Tier Tribunal rightly analysed in the paragraphs I just asked you to read, that's different from a situation which I accept would be closer to an abuse. I'm anxious not to concede anything, but I'm going to accept this is certainly closer to treaty abuse, where Sickle says to BLM, "We know that you should be entitled to a better tax treatment than we are, or you're entitled to be taxed in Ireland and therefore won't have to suffer withholding tax. But we're a bit worried about the ongoing, but we don't know quite what's going to happen with the litigation in the withholding tax in the Supreme Court. We'll do a deal. We'll pay you X, but there'll be a condition to X, which is we'll get more or you'll get more, depending upon whether ultimately you suffer the withholding tax." So somehow the deal is conditional upon a withholding tax contingency either happening or not happening. That might be different, where the parties consciously, and then a friend repeatedly used both in the First Tier Tribunal and the Upper Tribunal, this concept which is now abandoned of withholding tax arbitrage. Now, it's not a very helpful phrase because it doesn't, who knows what it really means. But in that kind of contingent deal, the position might be different. But we're not in that situation.
At the moment, not sure why it matters that you build in the splitting of the benefit as majority putting it dependent on a contingency or otherwise. I'm not quite sure why that makes a difference.
Well, you could imagine in those circumstances, and I haven't yet come on to the case law, but in accordance with Brebner, Kleinwort Benson, BlackRock, etc., it's all about the parties' subjective purposes. You can imagine a first-tier tribunal in those circumstances coming to a different view about what the parties' subjective purposes are. It goes back to the point. Well, let me come to the case law when I get to it.
Sorry.
My lord.
No, you finish your thought and then I'll
No,
let Rick mine.
What I was going to say is, I'm going to be. I have been implicitly critical of the revenue in not giving this court a dividing line as to where their case stops. And I've already made my submission that if it's really taken to its logical end, it's not just whether, as Mr. Brimsmead Stockham puts it, the whole of the profit is dependent upon the withholding tax differential, but because this is a main purpose test, and a main purpose has a connotation, simply something having a connotation of importance, more than the icing on the cake, as it were. Any time an important component of the price is reflecting that withholding tax differential, it's going to kick in. So I can't then duck my lord or my lady's questions about where my case falls. I mean, the answer is there are plenty of cases where Article 12.5 will apply, many of which are discussed in the conduit cases. So there's a clear area for its operation. And you know, and I'll come on to it, that when we get to the respondent's notice submission, which I'm going to be making relatively briefly in sotto voce, we'll be saying that's what it's really all targeted at and specifically limited to. but we are whatever the difficult cases on the penumbra. There's a clear bit in the middle of the Venn diagram where it clearly applies to conduit and other artificial cases. There are clearly cases like our case where it doesn't apply, and I accept, I think as I have to, that there is a central bit between the yolk and the white of the egg where it's a bit more difficult. And that may be the kind of case that my lord is asking me about. That's a very long-winded answer to your question. Sorry. So, can I then turn to what Mr. Brimsby-Stockham says are the two key errors in ground one, the abuse error and the starting point error? As I've already said, the revenue central case must be, I'm sorry for repeating myself, but whenever an interest-bearing debt claim is assigned and the price or economics of the assignment take into account as an important factor what I'm going to call the tax differential, that will necessarily fall foul of Article 12.5. And we submit that just cannot be correct. For the reason that's been identified by my lady in a discussion, which is that for BLM, which was a long-standing resident of Ireland, to be subject to tax in the Republic of Ireland on the SARD claim interest stream, which it beneficially owned, and beneficial ownership is part of the test, following an entirely commercial arm's length deal, was consistent with, entirely consistent with, the object and purpose of Article 12, and didn't involve improperly obtaining or taking advantage of that article. And just to follow through with that, I've emphasised Burlington's long-standing residence. And to go back to my Lord Justice Zacaroli's question, when else might Article 12.5 apply? It's possible that if an SPV is created, I'm conscious of the what was said in Vietjet that might undermine what I'm about to say. It's possible, I suppose, that in certain circumstances, depending on all the facts, if a Cayman parent creates an Irish SPV for a one-off purpose, the position might be different. I'm going to come back to my lady's observation in BlackRock at paragraph 150, and the words "something more is required." And I'm not, with respect, although I've compared my position and Mr. Brimsby-Stockham's position, I'm not the taxing authority. I don't want to sound too much like a public lawyer. They're the public authority. They're the ones that have to give a clear view to UK taxpayers about where the dividing line lies. It's not for me to give guidance. Sorry, it sounds again rather tendentious. It's not for this side of the court to give guidance as to where the dividing line lies. But it might. The something more bit might be the kind of circumstance I've just adverted to.
But that's still a case where the vice that you're getting at is a company in a third country which doesn't have the advantage of this double tax treaty, as it were, inveiling its way into this arrangement.
Right. It may be that at the time that the taxing authority invokes Article 12.5, the profit made by the treaty state, call it the Irish treaty state, has not yet been dividended up to the Cayman parent. So,
but if you go back to the commentary you took us to earlier, and there's a couple of examples given in one of the paragraphs that precisely relate to someone in a third territory, either transferring their residence to another territory which has a better treaty position,
moving their place of
or I forget the other example, but it was basically setting up a company, I think, in the treaty jurisdiction. I think that's a response to what my lord is asking.
It is, my lady, a better response than I've given. I don't just say that sycophantically. Yes, it is.
For myself, at least, I find those illustrative examples, which I think are just before the general bit of the commentary that you're relying on, instructive as to what is really being said.
I would respectfully agree. And the only reason I didn't read them out is because I wanted to draw a general principle. But the whole of the commentary needs to be read carefully.
Well, not the whole.
Not 1,000 and something pages on it. That bit of the commentary needs to be read carefully under the section improper use of the convention. So, as I've said already, for Burlington as a long-standing resident to be taxed in its jurisdiction or territory of residence is entirely consistent with Article 12. And the fact that Sickle, I'm sorry, I'm going to repeat myself, the fact that Sickle wouldn't have been entitled to benefit from Article 12 if, contrary to their liquidators' duties, they'd hung on to the claim rather than selling it for the, as they had to, for the best price they could on the market, doesn't convert all of a sudden BLM's ordinary entitlement into an abuse. Why should it? And that's the heart of Mr. Brimsmead-Stockham's case.
Well, you say, I think, as I understand it, you say, first of all, it's probably not right to talk in terms of BLM sharing the benefits with Sickle, because you say, well, BLM is entitled to the benefit of being Irish tax resident and the double tax treaty.
Yes.
And all it's done is pay an amount, calculate which reflects that to somebody who doesn't have that benefit. And you say it's not really right to talk about sharing a benefit. That's I think what you say is the wrong starting point. You just start from the proposition that BLM's in a position to make a better offer for the debt.
Yes, and the reason it had to pitch the offer where it did, rather than at say 80, was because of the economic reality that there are other purchasers out there in the market, UK pension funds, UK entities with trading with losses to offset, other potential.
This comes, I think you say this. Mr. Brimsmead-Stockham's argument comes from the mischaracterisation, I think, of the double tax treaty as being effectively concerned with the allocation of economic benefits as opposed to the allocation of
taxing
jurisdiction
rights.
To tax.
That's another way of putting the same point. Yes, my lord.
I mean I mean whether that's right or wrong, I'm not saying, but
that is another way of putting my point. Yes. Yeah. As I'll come back to when we look at the case law under ground 2, the tribunals below recognise that just because an assignment has economic consequences and that the price takes into account the differential, doesn't lead to an inexorable conclusion that the seller's main purpose or sole purpose is to take advantage of the article or its position under the article. And relatedly, as I've just started saying, in assessing BLM's purpose and why it priced the transaction in the way that it did, they were also right to take into account the range of potential buyers, competitive buyers out there in the market. So, and another way of putting the point is this: insofar as the economics of the situation were relevant, as Mr. Brimsmead-Stockham says they have to be, as part of the overall context in ascertaining BLM's purposes, then those economic consequences cannot be limited in the blinkered way that Mr. Brimsmead-Stockham suggests to Sickle's position on the false hypothesis that Sard was going to retain the claim. Particularly where, on the unchallenged findings of primary fact, Burlington knew that there were others in the market who would be prepared and able to pay more to the liquidators than the debt claim was worth in Sickle's hands. So the mere fact that by selling the Sard claim to BLM, Sickle received more than it would have done had it retained the claim, and Burlington paid less than 100% of the value of the claim, what Mr. Brimsmead-Stockham calls the splitting of the withholding tax benefit, does not lead to a conclusion that Burlington's purpose was to take advantage of Article 12. In that context, can I just go back to what Mr. Brimsmead-Stockham said or asserted was the purpose of Article 12? I've already agreed with him, and I'm going to garble the word again, that it was a distributive article allocating taxing rights between the two states. But he then goes wrong by saying that by including, and this is his language from yesterday, by including Article 12, the parties have agreed to their detriment and as a privilege to the other contracting party to give up their ordinary taxing rights. And as a limitation on that detriment, they've included Article 12.5. But that goes precisely back to the point that my Lord was just putting to me. It's just another way of putting Mr. Brimsmead-Stockham's starting point that somehow this should be seen in an analogous way to a UK domestic tax provision where UK tax should be being paid. But there is no a priori principle that interest that has its source in one state should be taxed in that state rather than in the state where the beneficial owner of the interest resides. And in this treaty, the parties have agreed that the starting point is the opposite.
I think that was also what I was trying to say with my, when you think of tax avoidance in a domestic context, it's putting yourself in a better position than the normal principles might suggest.
I mean, that's why it's so important in this case to start with what Article 12.5 means. So, although...
Well, you're starting with Article 12.1.
12, yes, required. Article 12. I mean, I don't know whether my friend did it for forensic or other reasons in light of the Vietjet, but throughout he's always started on ground one. He relegated ground one to the end of his submissions. But that's probably because he now recognises the difficulty in his ground one in light of Vietjet, which makes my case on the proper interpretation of Article 12 and in particular Article 12.5 very clear. Can I also deal with a related point? Mr. Brimsmead-Stockham said that the FTT had construed Article 12.5 in the same way that he put it, and in a fundamentally different way, he says, to the Upper Tribunal. But that's wrong. When you read the FTT's decision as a whole, they did not accept his submissions about the interpretation of Article 12.5, and that Article 12.5 is merely about a situation in which a party obtains the benefit under Article 12.1. Can we just look at that briefly? He started with a paragraph 136, which is at page 181 of the core bundle. And if you reread paragraph 136, I think Mr. Brimsmead-Stockham says that the FTT was there necessarily equating abuse with having a main purpose of obtaining the benefit. And that's not what the FTT was saying there, as the later passages in its judgment make abundantly clear. Can I just give you some of the passages in question? First of all, paragraph 149. Although we agree with Mr. Brimsmead-Stockham that the existence of artificial steps or arrangements is not a necessary precondition of the application of Article 12.5, we do not agree with his interpretation of the nature of the purpose which is a necessary precondition to that application. In our view, it follows inexorably from the language of Article 12.5. ... One is about sickle. Two, a person cannot have a main purpose of taking advantage of a provision... Sorry. It's one. In order for a person to fall within the ambit of the article, it is necessary for that person to have a main purpose of taking advantage, not just simply having the benefit of, taking advantage of Article 12.1 specifically. And then paragraph 168, page 197. (168.3), the respondents need to show that either BLM or SICL or both had as its main purpose or one of its main purposes taking advantage of Article 12.1 by means of the assignment. Then 1685, not necessary in order for 12.5 to apply for there to have been any artificial steps or arrangements, merely necessary for one or both of BLM and SICL to have a main purpose of taking advantage of Article 12, not just obtaining the benefit. Then 175, in the passage that we looked at yesterday, where my Lord Justice Snowden picked up the words more relevantly in parentheses about a third of the way down that paragraph.
But he goes on. They go on immediately to say in the next sentence, obtaining the benefit brackets or taking advantage.
Yes.
And in the next paragraph.
Yes.
How are we supposed to read that?
Well, can I finish the? Can I finish? You have to read the FTT's judgment as a whole, not as a statute, but as a whole. If you look at paragraph 197.
So did you take us to 176, or you were going to?
So I meant to.
Yeah.
And I think that's the passage that my Lord Justice Zacaroli was just referring us to. If you go also to paragraph 197. Where there's a rejection of Mr. Brimsmead-Stockham's approach to the scope of Article 12.5. And then at 201, in language foreshadowing what my lady said in paragraph 150 of BlackRock, the Judge Beer says at the foot of page 204 in the last sentence, we do think that in order for a person to be said to have a main purpose of taking advantage of a treaty relief itself in relation to a debt claim, something more is required than simply selling the debt claim outright for a market price which happens to reflect the fact that certain potential purchasers of the debt claim have tax attributes which the seller does not have, to a purchaser which happens to be able to pay that market price because it has those tax attributes by virtue of being able to entitled to relief under a treaty. All those passages, read as a whole, are inconsistent with the FTT having simply accepted the revenues case about the correct interpretation of Article 12.5. Can I finally, before moving to grounds 2 and 3, and briefly deal with our respondent's notice point? And I say briefly for two reasons. Primarily because in the end, we accept that this is likely to be an arid debate that won't make a difference to the outcome of this appeal. Given our primary case, confirmed in Vietjet, that Article 12.5 only applies in circumstances involving a party improperly taking advantage of 12.1. Whether 12.5 is also specifically limited to transactions involving artificial arrangements is likely to be an academic debate. Indeed, it's difficult to conceive of a large range of cases, or indeed perhaps any case, which would involve improperly taking advantage of Article 12, but that would not involve something that could be characterised as artificial. I mean, that kind of begs the question, what do I mean by artificial?
Well, it begs the question, what you mean by improper?
Well, one has to discern that from the OECD commentary as a whole.
Yeah, I think artificial is slightly clearer than improper.
Well, perhaps that...
If the question begging, I would have thought it's...
I think the problem, one of the problems may be that improper, you can pick that up from the commentary.
Yes.
Artificial, one of the concerns about that is, as has been pointed out, it's not written into the treaty, but also even if you might think that most cases of improper taking advantage of would involve artificial steps, you can't exclude the possibility that someone would think of something much more straightforward
Yes.
that would also have that characteristic.
And I see my own friend going like this. In other words, yeah, that's this case. It's not this case.
I'm not saying it's this case, I'm trying to
Yeah, no,
think
I
about
understand.
what the correct legal test is.
Yes. I'm conscious of the time.
Yeah.
And what I want to do next is to show you just two bits of material in the authority that we haven't yet looked at that support the artificial, the mischief being got at by...
How long will it take you to show us those two bits? And,
less than 4 minutes.
and how much progress are you making?
Good progress.
Okay, well, let's go for the 4 minutes and see where we are in 4 minutes' time.
Okay. The first is tab 39 of the authorities bundle. Which is the United Nations Model Double Taxation Convention commentary, which it's been common ground throughout can be taken into account for what it's worth. And I'll show you why that's particularly apt in this case. Could you turn, please, straight to page 948 of the bundle? And you'll see at the foot of the page, the very last two lines, a suggested provision which is in the same terms as we are concerned with in this case. And then you look back at paragraph 23. When this issue was last considered, some members of the formal group of experts, I'm going to show you who those were, pointed out that there are many artificial devices entered into by persons to take advantage of the provisions of Article 11 through the creation or assignment of debt claims, in respect of which interest is charged, while substance over form rules, abuse of rights principle, or any similar doctrine could be used to counter such arrangements. Contracting states, which may want to specifically address the issue, may include a clause on the following lines in their bilateral tax treaties.
That's just saying you can deal with artificial
by this
structures by this clause, but it doesn't say this clause is only there to deal with artificial.
That's what the tribunals below concluded. And a friend again is vigorously nodding his assent. I can only show you what the material says in my submission. Okay. It shows you what the mischief is being attacked by the provision. And I suspect I'm going to face the same response to the next thing I'm going to show you, which is the Hansard report at the previous tab 38. And the relevance of this is that it's the debate in December 1998 at the time of the amendment of Article 12.5 through the protocol that my friend showed you yesterday, and it's a question and answer given by Dawn Primarolo in answer to a question from another member of the House, Nick Gibb. Can I just pick it up at the foot of 936 in the penultimate paragraph? He says, sixthly, I refer to Article 3 of the protocol, which is the old version of Article 12, the interest article. The former Article 12.5 said that the treaty would not apply if the debt was created mainly for the purpose of using the treaty as a standard anti-avoidance provision. How does the new wording change its meaning, and why has it been changed? And Dawn Primarolo's answer to that is at the last paragraph on page 938, foot of the page. The Honourable Gentleman then asked about Article 3 in interest. There are no equivalent provisions to those of the OECD. The article is an anti-abuse measure designed to prevent artificial arrangements which exist mainly to obtain the benefits of the Convention. Now, there's a whole issue which I will deal with as quickly as I can at 2 o'clock about whether that Hansard debate is, or as the FTT found, is not admissible as an aid to interpretation of the Convention. In short summary, I'm going to say it is, because it's admissible under the Vienna Convention as a supplementary means of interpreting the treaty. And to foreshadow what I'm going to say very briefly, I accept that for that submission to be made good, you would have to accept the inference that when Dawn Primorello came to the House and said what she said, that reflected the joint understanding of both the UK and Ireland in the treaty negotiations which had just been concluded. If that's a fair inference, then this explanation reflects the joint position of the parties and should be admissible. If it's not,
this is all on the footing that the answer is focusing on the question about whether it's only artificial.
Well, so there are 2 hurdles I have to surmount. One is that this is admissible at all. 2, if it is, does it help? The answer to both those questions was adverse to me in the FTT. The Upper Tribunal didn't engage in the interesting question about whether it was admissible and said it doesn't really help me, it doesn't get me as far as I need to be anyway. If the court is of the same view as the Upper Tribunal, then there's not much point in spending time on the interesting but hypothetical question of whether it's admissible or not. I can deal with that very briefly after lunch.
Well, let's deal with that after lunch. And you say you're doing well enough to be able to give Mr. Brinsmead Stockton some reply.
Yes, I am sure. I'm not sure. Can I just check how far I've got to go?
Well, I mean, I'm perfectly happy for the 2 of you just to have a quick exchange between you when we rise, and let us know. Hopefully, you agreed how you're going to divide up the remainder of the time that we have.
Thank you.
All right. So we'll come back at 5 past. No, we won't. We'll come back at 2 o'clock.
Okay.
All right.